In a rape case, the accused argues for his defense that the house was small, such that it was highly unlikely for him to have molested the victim without the other family members noticing. Is this defense tenable? No. Rape can be committed even in places where people congregate in parks, along the roadside, within school premises, inside a house where there are other occupants, and even in the same room where other members of the family are also sleeping.
Elements of rape through sexual assault are as follows. 1. That the offender is a man. 2. That the offender had carnal knowledge of a woman. And 3. That such act is accomplished by force or intimidation. Are the elements correct? No. To prove rape through sexual assault, the following elements must be established. 1. That the offender commits an act of sexual assault. 2. That the act of sexual assault is committed by inserting his penis into another person's mouth or anal orifice or by inserting any instrument or object into the genital or anal orifice of another person. And 3. That the act of sexual assault is accomplished by using force or intimidation or any of the circumstances enumerated in Article 266a, 1.
Is common law relationship a qualifying circumstance in lascivious conduct? No. Common law relationship is not a qualifying circumstance in lascivious conduct. Common law relationship is considered a qualifying relationship only in rape under Article 266a of the Revised Penal Code. It is notably omitted in the enumeration under Article 31(c) of Republic Act No. 7610 and even as an alternative circumstance under Article 15, wherein relationship is always considered an aggravating circumstance in crimes against chastity.
Can moral ascendancy of the accused substitute the element of force, threat, or intimidation in lascivious conduct? Yes. Accused's moral ascendancy over his child victim substitutes for the element of force, threat, or intimidation since the relationship and close proximity of the victim and the offender amplifies the fear of the former which subdues her to silent submission.
Does the term, other sexual abuse, includes all other acts of sexual abuse other than prostitution? Yes. In People v. Tooligan, the court clarified that other sexual abuse is a broad term that includes all other acts of sexual abuse other than prostitution. Consequently, a single act of lascivious conduct may be punished under Section 5(b) of Republic Act No. 7610 when the victim is at least 12 years old but below 18 years old.
Is violation of Section 5(b) of Republic Act No. 7610 malum prohibitum? Such that, the mere act of committing lascivious conduct with a child subjected to sexual abuse already constitutes the offense? Yes. Settled is the rule that violation of Section 5(b) of Republic Act No. 7610 is malum prohibitum. The mere act of committing lascivious conduct with a child subjected to sexual abuse already constitutes the offense.
To warrant a conviction of lascivious conduct under Section 5(b) of Republic Act No. 7610, the following elements must be shown with moral certainty. 1. The accused committed the act of sexual intercourse or lascivious conduct. 2. The said act is performed with a child exploited in prostitution or subjected to other sexual abuse. And 3. The child, whether male or female, is below 16 years of age. Are the elements correct? No. The age in the third requisite must be below 18 years of age, not 16.
Can an accused invoke double jeopardy if the trial court acquitted him without giving the prosecution a fair chance to present its evidence? No. Double jeopardy cannot be invoked when the prosecution is denied due process in securing a conviction. The trial court acquitted the accused without giving the prosecution a fair chance to present its evidence, thereby denying it due process. It is settled doctrine that double jeopardy cannot be invoked against the court's setting aside of the trial court's judgment of acquittal where the prosecution which represents the sovereign people in criminal cases is denied due process. For the cardinal precept is that where there is a violation of basic constitutional rights, courts are ousted of their jurisdiction.
Before the trial court, all criminal actions shall be prosecuted under the direction and control of the public prosecutor, who represents the people. Once the case ascends to the Court of Appeals or the Supreme Court, however, the 1987 Administrative Code explicitly vests such representative authority to the Solicitor General. Is the statement correct? Yes, the statement is correct.
In criminal actions, the real party in interest is the people of the Philippines. Consequently, it is the people who wields the inherent prerogative to prosecute the offense, which includes the authority to appeal from the accused's acquittal, the dismissal of the case, and other interlocutory orders relating to the criminal aspect of the case. Is the statement correct? Yes, the statement is correct.